We have a big legal battle that will absolutely implicate your rights happening in the case of maybe Bonta coming out of California. We're dealing with so many different things about where you can carry a firearm, where the government may set as a sensitive location, because basically they've turned a lot of the state of California into a sensitive location. And we've got a very interesting situation that is brewing where the federal district court judge says, nope, this is enjoined, meaning it has been paused and does not go into effect, in a 43-page decision linked in the description box below, only to be reversed by the Ninth Circuit Court of Appeals on what's called an administrative stay, allowing now the law to go into effect. What does that all mean? I'm going to cover this. I'm going to try doing this really quick in a speed run for you guys. I know a lot of my videos are very long. I'm going to try making this short. I want your feedback on what you like. We're going to go through very low resolution what happens here. I'm going to go higher resolution in one of the particular trenches of this battle so you can see how it all plays out. My name's Tom Grieve, Second Amendment attorney. Guys, let's get into it. December 20th, 2023, the federal district court in California, which is the trial court judge, enjoined California law SB2 from going into effect in a 43-page decision. Then on December 30th, the Ninth Circuit Court of Appeals stayed that, effectively reversing that preliminary injunction. Now, reminder, preliminary injunctions does not mean that that's a final order from the court. But why is this so important? Because a lot of the issues that go into whether or not a court should enjoin a law basically go into who's going to probably win this at the end of the day. So I know a lot of folks in the comment section say, Tom, just cover this when this is done. That's kind of like starting to cover World War II in April of 1945. It's already over at that point. We want to look at the decisive conflict points, and that's exactly what we're doing here. So first off, in response to SB2, we saw a number of legal challenges that got combined together, brought from a variety of different groups and individuals, including, but not limited to, the California Rifle and Pistol Association, the Firearms Policy Coalition, the Second Amendment Foundation, and the Gun Owners Foundation, who have challenged a lot of the constitutionality issues surrounding the sensitive places. Now, California put 26 new places as being illegal for individuals to carry. You can find the total list described in the description box below. It is extensive, covering medical facilities, you name it. One of the big things I want to call your attention to, though, is something that I unfortunately was correct in predicting. We're going to see this as an ongoing trend, what I call the private property inversion. In other words, where California has set the default legal status for malls, shopping centers, basically all commercial that's held open to the public. Think about Walmart, for instance. The default carry status is now illegal unless they post to allow carry. Right. Now, if you were in New York City, that would make approximately 91% of New York City illegal to carry on, as another judge in New York case actually noted by doing that inversion. So these things may seem kind of minor, but they are actually huge, huge deals. And we have to remember, the Second Amendment has been guaranteed to protect your rights, to protect your life, your friend's life, your family's life, both inside the house as well as when you go forth and carry in public. So what we're seeing here is a test of the elasticity of a lot of these arguments concerning what falls within the nation's historical tradition. And since, frankly, very few things fall within the nation's historical tradition, really what you're going to see is an ongoing trend emerge and play itself out here, whereby the government is forced to stretch. What are the analogs of, well, look, this is going to be okay, and that means that really we're going to push the lines over here because this is analogous enough. And again, I'm going to be taking you inside the ring on one of those particular issues as it deals with the mental health facilities and so forth. Because I think that if you see that, you're going to understand just how insidious a lot of this logic is. But the bottom line, and the reason why this is such a critical issue, is that if the Second Amendment side loses the sensitive location arguments, and if the government is allowed an enormous amount of room to maneuver, of elasticity, of ability to stretch the analogical reasoning of these historical history and tradition tests, you're not going to be allowed to carry anywhere. Let me restate that. You're not going to be allowed to carry anywhere. The government and the anti-gunners are trying to make everything a sensitive location, meaning it is prohibited by law. period. That's the reason why this is so critical. And we're seeing a couple big tests emerge on this point. Today, we're talking about the California one. Elsewhere, I've also talked about the New York one. So let's recall that we have our Supreme Court holy trinity of cases that have come out to really define what are the limits of the Second Amendment. We've got DC versus Heller from 2008. We've got McDonald from 2010. And now in 2022, we've got the Bruen, that's BRUEN decision that have come out. And importantly, the Bruen decision gave us the legal contours or the battle lines of what courts are supposed to be doing in order to determine whether or not a law that seeks to regulate a Second Amendment protected activity is actually constitutional or not. So in other words, if courts are the umpires and if the government's the pitcher deciding where they're going to pitch, i.e. whether they're going to pass laws and how they're going to regulate, the court in the Bruen decision said, this is the limits of the strike zone, ball or strike. It's either constitutional or unconstitutional. The gist to this, which I've explained many times before and I'll quickly cover here again, is it's a two-part test. Part one is, does the law seek to regulate or does it potentially infringe upon some sort of protected Second Amendment conduct, which includes bearing weapons, the possession of weapons, and carrying weapons? It's more nuanced than that, but again, this is the speed run on this. If the answer is yes, and by the way, the answer here was yes, okay? If the answer is yes, then you move to step two, which is where the government bears the burden of proof, not you, the individual, but the government bears the burden of proof to show that that particular law or regulation is consistent with the nation's historical tradition of firearms regulation. To do so, the government does not need to find a historical twin in the nation's history and tradition. And by the way, that history and tradition typically needs to be sourced from the colonial times, the times of the drafting of the Second Amendment around 1791. And depending upon where you draw that line as you go through history is going to kind of determine what kind of result, frankly, you want. Pro-Second Amendment people, we're talking about, of course, the early Republic, often through 1830s, for instance. The anti-crowd have tried to claim 1990s, and beyond, and I'm not joking when I say that. It seems like a lot of the individual battle lines on this particular issue where we draw the line may go to 1868 and the ratification of the 14th Amendment, but we'll see. We're going to be talking about some laws that come from the 1870s, however. Guys, if you want a more in-depth breakdown of the Bruen test, let me know in the comment field below. I'd be happy to do a longer video on it. I ask this from time to time. I see occasional comments scattered about that. So I don't like to do long stuff unless people want it, particularly when it's on kind of a dry topic, which is interesting to me, but it may not be to you. So let me know in the comment field below. Okay, time for that obligatory self-promotional pause. Don't forget to hit that like button if you've made it this far in this video. If you're getting something out of it, leave a comment down below. I do my best to read through as many of them as possible and to respond to as many of them as possible. I look forward to joining you in the comment field discussion. Now back to the video. Short answer, dear Lord, yes. So the government does have one pushback point, which basically goes something like this. They say between 1791 and 1868, the ordinary American at that time would not have conceptualized their right to carry arms as extending to other people's private property without that property owner's consent. That's really the only thing they have to say about that, and the court just dismisses it and absolutely says no. The court disagrees and counters that the regulation prohibits concealed carry weapon permit holders from carrying firearms in places open to the public to defend themselves and their families. The court says that this surely falls within the Second Amendment right to carry firearms in self-defense outside the home. As already mentioned before, New York tried this very same tactic and likewise was shot down when it comes to setting the default carry on locations to being illegal because, of course, New York Island is 91% privately owned and as a result would be restricted locations if the government was allowed to set these defaults in place. So in essence, if you're allowed to set the default as government, Second Amendment virtually done is what the court says, and as a result, no go. Look, it would be a multi-hour video to examine every single argument made and countermade in this case, so I'm just going to take you into the ring on one of them, which deals with medical facilities. So the government made carry in any medical facility illegal. Let's take a look at this because you can kind of see how this reasoning maps to frankly everywhere else. Given the nation's history and tradition of protecting the core right to carry a firearm to those wishing to defend themselves and their families in case of confrontation, the court wrote that it is unsurprising that the government does not offer a single historical prohibition on carrying firearms at hospitals or medical offices, much less one limiting carry by a category of people who are so particularly responsible and trained that they've gone through the California onus and burden of getting a concealed carry license. One research paper cited in this case notes that, look, there had been hospitals that did exist before 1791, but they were admittedly rare. Doctors' offices, not so rare. As the author of that research paper wrote, quote, "I have never seen a law restricting arms possession in such places," end quote. Other courts and scholars have surmised the difficulty of classifying all these medical facilities into becoming sensitive locations. In the Antoniuk versus Hockel case, that's the New York case I've referenced, the court there wrote, quote, "Certainly the medical profession existed in the 18th and 19th century America, and certainly gun violence existed in 18th and 19th century America. Yet, the state defendants do not cite, and the court has been unable yet to locate, any laws from those time periods prohibiting firearms in places such as almshouses, hospitals, or physicians' offices," end quote. Another case in Coons versus Plotkin wrote, quote, "This court has uncovered no laws from the 18th or 19th centuries that banned firearms at hospitals, almshouses, asylums, or other medical facilities," end quote, from page 93 of that case. But of course, as we already mentioned, the government does not need to present a historical twin for the regulation to be lawful. It just needs to present a historical analog. So it can stretch a little bit, provided that it's going from one area that's the same to another area that's the same. Here's what they said. The government contends that SB2's ban on permit holder carry in medical facilities, quote, "fits within the nation's tradition of sensitive place restrictions because modern healthcare facilities exist for scientific and educational purposes and serve a vulnerable population," end quote. Okay. So to support this, they cite three laws. The first from 1870 Texas to, quote, "any schoolroom or other place where persons are assembled for educational, literary, or scientific purposes," end quote. Number two, 1878 Mississippi law prohibiting any student or any university, college, or school from carrying a concealed weapon. And number three, an 1879 Missouri law prohibiting concealed carry in any schoolroom or place where people are assembled for educational, literary, or social purposes. Now, the government argues that these laws were designed to, among other things, protect the vulnerable persons, as they already said, who, because of their age or physical state, cannot easily escape attack, much less defend themselves. And again, the court basically just says no. The government provides no evidence that the proffered analogies, those three laws, prohibiting firearms in places where people gather for, quote, "scientific or educational purposes," are well established, representative of the entire country, or consistent with the tradition of banning firearms in places like hospitals and urgent cares. Nor, as the court goes on to observe, are the proffered analogies relevantly similar, because SB2, which prevents people that law enforcement has already vetted, because remember, they went through a very rigorous process to get their concealed carry licenses, because SB2, which prevents people that law enforcement has already vetted and who have already been trained on the carry and use of their handguns from carrying those handguns to defend themselves and their families in case of confrontation in places that they visit in everyday lives, imposes a far greater burden on the right to self-defense than the proffered historical analogs with non-comparable justifications. Moreover, if the so-called settled constitutionality of prohibiting firearms in schools is sufficiently analogous to a regulation prohibiting firearms in medical facilities, then as the court points out, that logic is broad enough to altogether eviscerate the general right to publicly carry arms for self-defense. The bottom line, no. The court says if we're going to stretch the strike zone that far, you can hit the batter and that's going to be okay because, hey, everywhere that you're standing in dust or dirt, representing the home plate proximity, that's all the strike zone. That's all going to be legal. If you're going to be allowed to stretch the strike zone like this for medical facilities, then the Second Amendment's done. Not going to be able to carry anywhere. So now enter the Ninth Circuit Court of Appeals. So California Attorney General Rob Bonta quickly asked the Ninth Circuit Court of Appeals to put that injunction on hold pending their appeal, saying that leaving the law blocked would mean that tens of millions of Californians will face a heightened risk of gun violence. The three-judge panel in the Ninth Circuit Court of Appeals issued an administrative stay, which temporarily puts the injunction on hold until a different Ninth Circuit panel can consider whether or not to pause the lower court judge's order for even longer while the litigation plays out. So too long did not read. Trial court blocked it. Ninth Circuit Court now blocked the block. The law is back on. Here are some key takeaways before the quote of the day. Number one, states are obviously copying radical gun control models from one another. I mentioned, of course, California has copied New York. Don't think that other states, including your own and virtually any purple state where the anti-gunners get control, won't be next. Number two, gun controllers are going to need to stretch the historical analogs as part of this history and tradition test to make their laws found legal. And no doubt, they will find judges who will be happy to do so. This is going to be a key battleground, is how elastic are these historical analogs and twins? How elastic are these going to be allowed to become? Because if they're allowed to basically be stretched, Second Amendment's done. And basically the so-called exceptions will swallow the rule. Number three, all of this is going to eventually be sorted out by the Supreme Court. The U.S. Supreme Court has already accepted 3 Second Amendment cases in the last 6 months, have already heard oral arguments on one of them. I think we're going to see a case like this dealing with sensitive locations absolutely hit their docket for late 2024 to 2025, and of course could in no small way be shaped also by the next US presidential election, because of course the commander-in-chief, the president, that's the person who decides who sits on the US Supreme Court. We appreciate you sticking around this long. I tried to do a speed run on this. There's just so much to cover here. Let me know what you thought about this speed run attempt in the comment field below. I look forward to reading your comments as always. Show your support for the Second Amendment. Hit that like button. And of course, you just found us browsing through. Don't forget to consider hitting that subscribe to make sure you don't miss any of our future content. And now to our ever famous quote of the day. This one comes from Friedrich Nietzsche. Quote, "Hilarious are the weak who think they are good because they have no claws." End quote. There's a lot to unpack in that one. I look forward to joining in the discussion in the comment field below. We'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.